Thank you. On the last occasion, the court excused certain counsel who were unavailable. However, the arrangement was that in this intervening week, issues pertaining to the docket that counsel may have had be taken up with you and hopefully sorted out. Mr. Radebe, for accused one, are you in court?
I am in court, my lord.
Yes. Have all issues pertaining to the docket content been sorted out with counsel for the state?
Well, my lord, we received the drive today, and the commitment from the state is that everything is in it. So I'm here to go through the drive, and then if there's anything, I'll take it up with my legal call from the state. But the commitment is that everything is in the drive. As a court, please, ma'am.
Thank you. Regarding Mr. Kruvier, who indicated that he wouldn't be here, he stated that he had an issue relating to a 2-page document that he was going to take up with you. Did he do that? Or?
My lord, no, there was no further follow-up from Mr. Kruvier. All I did is he provided me with electronic devices for downloading, which I did,
yes.
And I informed him that it's ready for collection. He said he'll collect it today.
Okay, and you referred to a ballistic report.
That has been, yeah. In fact, I received those ballistic reports yesterday morning.
So you will furnish him
already furnished
with that, and then if you will just remind him, because he indicated that there was a 2-page document.
I'll ask him. Yes.
Okay, so that
yes.
Those issues can be finalized. Ms. van den Heever, I will come back to you. And then there was Advocate Tansi. He also indicated that he may not be here, but he did not raise any issues
Yes, my lord, and he has
regarding
been
the document.
He has been furnished already, yes.
Yes, thank you, Ms. van den Heever.
May I please, Your Worship? Your Worship,
we indicated on the last occasion, you explained to the court the difficulties that you had encountered with regard to consultation and taking instruction and so on. And the arrangement was that in this intervening week, you and counsel for the state would attempt to communicate with correctional services with regard to the possible transfer of accused number 3 to the Gauteng area.
Your Worship, sorry, my lord, I beg your pardon. My lord, we indicated to the court, let's start with that issue. I've indicated to the Honourable Court on the last occasion that my attorney did direct a letter to Correctional Service to the National Commissioner Let me hand this up, then your Lordship can maybe follow from the bundle that we've prepared for the Honourable Court. So just to go down with the sequence of events, on the 15th of January, my attorney directed a letter to the National Commissioner of Correctional Services and served same by hand on the very same day, in which it's a 3-pager in which they've explained the issues that was encountered with consultation at Mongweni. Also attached to it was the indictment. When we appeared in court on the last occasion, my Lord, you will recall, I've placed on record at that point we still had not received any response thereto.
Yes.
Subsequent to that, a further letter was served again per hand on the National Commissioner on the 3rd of February 2026, to which we again attached the previous letter dated 15 January with the annexures thereto. As of this very moment standing here, we yet to receive an answer.
Yes.
I beg leave that those documents be accepted and form part of the record in this matter at this point in time.
Yes. Let me just ask you, when was accused number 3 transferred?
He was transferred midnight on, may I just approach him for the exact date,
Yes, sure.
my Lord? 21 December, somewhere in the middle of the night. As I indicated, he was spirited away from CMAX down to Mongweni.
The 21st of December.
December, yes. I'm not going to go into all the details of what transpired after that. I don't want to burden this particular record, my Lord.
Yes.
Let me at this point leave it where I've got it here, because we're going to deal with it in due course. My learned friend was so kind. I spoke to her, I think, yesterday, and I asked her, in the light of us not having had the courtesy of a response from the National Commissioner, if she perhaps received a response, and she emailed myself and my attorney a response that she received, and it came from the Regional Manager Correctional Services, and it is dated 30 January 2026. I don't think my learned... Oh, this is from my learned friend. I've got her response too. So that was her letter that she addressed to them. I beg leave to... I'm sure she won't mind it. Oh, you've got that one. My learned friend then...
You say that...
So she
never received, she forwarded a letter.
Now she forwarded a letter to them, and she got a response. I'm just trying to find...
I interrupt my learned friend, but may I assist the court? So the court requested the state to assist in the matter, which we duly did. We directed correspondence dated the 30th of January, which your lordship have in front of you now. And
To who?
to the National Commissioner and several other email addresses. And then they graciously replied to our request dated, I think it was the day before yesterday, which was the 4th of February. Their correspondence were directed to us. So both those correspondences are before your lordship, and it's been handed to the court.
What was the import of
The import is, my lord, is that the Correctional Service Department indicated that they still rely on Section 6 and their independent mandate to transfer prisoners to wherever they want to. They place it also subject to Section 73 of the Criminal Procedure Act, which the gist of Section 73 of the Criminal Procedure Act says the following. It says that access to legal representation by detainees is...
Whose cell phone is on, please? If that cell phone rings again, I'm going to ask the orderly to please transport the person outside of this court.
Thank you, my lord. Section 73 in short says, yes, access to legal representation is a human right, but subject to other legislation, which is in section 6 of the. So that is what they quote there in their response. They indicate there that a risk assessment was done. I requested informally at a meeting with correctional services, can we have the risk assessment? They said it's confidential, so I don't have it, my lord, but what I could see from the correspondence.
Sorry to interrupt you. Please, you may be seated. Sorry, I forgot to.
What I could gather from, if you read through that correspondence.
I don't need to read through all of this. I can tell counsel now.
Yes.
I'm not going, this court is not going to be drawn into an opposed application relating to the issue of accused number 3's incarceration wherever. However, the court did indicate on the last occasion that if there was no joy, especially by the defense, because it is obviously the defense who is affected in consultation and so on. You know what your rights are, Ms. van der Heer. But, and again, the court reiterates that the court sympathizes with you and the frustrations and the hurdles you are experiencing in attempting to consult. But having said that, obviously the state or correctional services in particular have got their reasons why they are of the view that your client ought to be kept
My lord,
in that facility.
We 100% in agreement. I'm not going to draw your lordship into that. It is, however, as I think it's been stated in the Supreme Court of Appeal, I have to place these issues on record because yes, that's the manner in which I protect my client's rights down the line, and for that purpose I do that. So your lordship has got the papers, you don't have to go through it. It just explains to
yes,
you
the
state got an answer,
yes,
but we did not get an answer, and we're in the process of dealing with this particular matter. However, my lord,
and it would appear though that there's no imminent joy.
No, there's no imminent joy, but that has given us a further hurdle. And I need to place this on record because it affects the process that's before you at this point in time, my lord. Yes. We were here last week to do a pre-trial. The facts of the matter is the following. My learned friend last week placed on record that we requested certain disclosure. Disclosure was finally given to us on Monday. However,
well,
Monday
was that not the additional disclosure?
That was the additional
because
disclosure.
Counsel for the state did indicate that disclosure was made last year sometime.
Yes, so this is what they call additional disclosure. We respectfully submit based on it. And again, Lord, I'm not going to argue this fully before your lordship. We respectfully submitted disclosure that needed to be given to us in any event. It's part and parcel of the case, the applicant's rights at the end of the day to have such disclosure. So we were handed 1 terabyte of a hard drive on Monday. However, we could not open it. There's specific software, there's an app allegedly that's needed. So let me just go very brief. Monday it was given to us. We endeavored to open it on Monday. It became patently clear that we can't open it. On Wednesday, arrangements were made with my attorney made arrangements with my learned friend to come back to also explain to her that from the 1 or 2 documents that they could see, we need additional documents, so we needed certain affidavits. We got a USB stick with that. Those documents, however, also was not the complete picture. Where we are right now is my attorney went back and spoke to my learned friend about the issues with the terabyte. She then said speak to the forensic department and see if they can be of assistance. Their response to us was simply, go and get an app and deal with it. That, my lord, with the greatest of respect, is not how we do disclosure. You need to give us the disclosure we request, and it's always been like that, in a readable format. We do not have disclosure in a readable format. In addition, I had a very amicable conversation with my learned friend yesterday, in which I indicated to her that in the docket itself, off the record, there's certain documents, but it all relates, again, my lord, let me make it very clear, to the terabytes that we have not been given in a readable format. My learned friend approached me this morning and said, and I don't think she will mind if I place it on record, she can deal with that when it's her turn, that they basically, at this point, it's simply, they will need to go back and see what they can do. However, my lord, this impacts on a number of my clients' rights. One of it is, again, and I don't want to repeat myself, our right to a speedy trial. It also impacts on my client's right to bring a bail application on new facts that again relates to the delays, etc., etc. So at this point in time, my lord, because all of this just happened, before I can even approach the court with some kind of application, I'm going to ask, I've canvassed it with my learned friend, that the matter stand down. I've not had an opportunity to consult with my client, give him the feedback, take proper instructions from him on certain issues, explain to him what's happened. So I've indicated to my learned friend that I'm going to ask that the matter stand down before I can, based on proper instructions, approach this court and deal with the matter further at this point in time. I've also indicated to my learned friend, from my experience last week, what I would like to do is make use of the consultation, the designated consultation rooms that are downstairs to have this consultation. Last week, we were forced, we were given 2 minutes to have a consultation with 100 people around us through double bars, trying to take instructions where people are listening, which is just not the manner in which one takes instructions, especially on issues like this. So at this point, if the court would bear with me, I need at least half an hour. I need to explain to the client what is currently going on. I need to take instructions. I can also place on record that my attorney has attended to my client on various other issues. Because of us waiting to see if we can't get a better version of the hard drive, we've not been able to discuss with him where we are right now. And it's for that reason I ask the court's indulgence that we stand down so I can have the opportunity to consult with my client downstairs and deal with this particular issue, so that I can come back to the court and deal with what the way forward is based on instructions that I get from the client.
Yes.
My learned friend doesn't have an objection that we stand down. I do not wish to inconvenience the court, but I have to, at this point, take those instructions.
Sure.
May I please?
Ms. LaRue, just if I may state at this stage, obviously, and regardless possibly of the lack of sophistication of the IT issues or apps or laptop that counsel for the defence has. You are aware that counsel are entitled to something in a form that they can access and read.
Yes, my lord, of course that's a reasonable request.
Yes.
So I was, up to this morning, I was unaware that there was a problem. I was
Yes.
hoping, because of the lack of my IT expertise, I was really hoping that our IT expert could assist the defence. Apparently
yes.
that has not happened, so I will
There's no use speaking about that too much, because I think I am the most IT retarded among all the people in this court. However, the defence obviously are entitled to
Yes, my lord.
all of that. That was the first issue before I adjourned. The second issue is this court has done this on multiple occasions where there are issues with different accused. And there is nothing in the law that prevents me from doing this. And that is that in the event, and of course with some of the counsel not being here, it can't be decided on today. But the court is amenable to conducting a pre-trial in respect of certain of the accused. In other words, to do it on a piecemeal basis. So if, for example, hypothetically speaking, there are no issues with regard to the finalization of a pre-trial, not today, but in due course, of accused 1, 2, 4, and 5, or 1 and 2 at one stage, and on the next stage, the court is amenable to doing it.
Thank you, my lord. I take note of that, and I will take it up with counsel.
Because that is basically the court's function,
Yes.
is to
Case managed.
basically get the matter trial ready.
Yes.
And if there are obviously issues with a certain accused, well then that pre-trial can be delayed or dealt with at a later stage.
That's
Okay.
correct, my lord. I just want to place something on record which I think in defense of the Correctional Services Department, which is not represented here, is that from this correspondence that I received from them, is that they are not unreasonable in granting access to accused number 3 for consultations. In fact, they allowed his attorney to consult with him at Vusimuzi earlier in the week for about 2 or 3 hours. So I just want to place that on record. It's not as if he's not at all accessible to the legal team. As a
Ms. Finding here that this court has not for some years now been to the cells in this court, but to the best of my recollection, at the very bottom,
There's a facility.
don't you get locked in the room with your client and there are no windows there and
There's 2 doors.
100 guards outside, but you and the client are locked in and you consult.
Yes, we've got no issues with that. When we tried to do that last week, there was an issue. I don't want to complain about last week. I right now just want to go to that consultation room, thick glass in between us, one door on the one side, door on the other side. We're quite happy to be locked in with the
That's
client.
the one on the other floor. But I'm speaking about at the very bottom. There are locked rooms with no windows. There are 4 walls and a door. And you...
That would be very convenient, my lord. As I said, I don't care to be locked in with my client and my attorney. We're quite happy. We just need time to speak to each other and decide on a way forward in this matter. That's all we need at this point. As I said, there can be 100 guards outside with big guns.
Yes,
Not
and
an issue
obviously
to us.
counsel are searched and
We're quite happy with that.
security procedures, and then you get locked in with the client.
We're quite happy with that.
Yes. And then finally, before I adjourn, Ms. LaRue, there's just something that I wanted to raise with you actually last week, but I did not. If one looks at the indictment, on the first page, there is the count of conspiracy to commit murder. There are 3 counts. On number 2, there are 11 counts of attempted murder, and so on. Now, on my calculation, and let me just remind you that my maths isn't that good, but I get to get to 24 counts. However, when one reads further in respect of each incident, there are 25 counts. So there's something wrong.
I'll have a look at that, my lord.
Please do. And it's not because of the alternative in certain of the accounts. If you add them up, they come to 24 counts, but in the body of the indictment it refers to 25 counts.
Thank you for pointing that out.
That was the one thing, and it was just another thing that if you look at page 10 of the indictment, the alternative to count 18 that relates to accused 3 and 4. Tell me when you're with me.
Yes, my lord.
Yes. In that, on or about the same date, the same time, date, and place referred to in count 18, the accused did wrongfully and intentionally attempt to defeat or obstruct the course of justice by arranging the creation of a fraudulent invoice referred to in, should that not be count 17 and not count 18?
Let me have a look, my lord.
Yes, because count 17 is the one that deals with the fraudulent
Deals
invoice.
with that, yes. My
So
lord,
it's just
sometimes,
two things that I wanted to.
yeah, sometimes typographical errors sneak
No,
in
absolutely.
with the copying and pasting of
Yes.
changing.
But I think more importantly is the number of counts.
I will have a look at that.
Thank you.
my lord.
It is now 10 past 11. Do you want the court to resume at a quarter to 12 or at 12?
I would ask for 12 at this point, my lord. If there is a further issue, I will let your lordship's registrar know, and my learned friend, I will let her know too.
Yes. Ms. Leroux, is that in order?
That is in order, my lord.
Yes. Very well. The court will then adjourn until 12 o'clock.
Sorry. Let's go down.